Hi, this is Shelley Crafter. We're coming to you live at the Aegis Capital Healthcare and Technology Conference 2014 in Las Vegas, and we're doing a Wall Street view with Kristen Young from Zag-S&W Attorneys at Law. Welcome to your Wall Street view.
Thank you so much for having me, Shelley.
It's good to have you. So we prior discussed, you're an attorney, you're in the world of the microcap world, discussing 506, the Reg D, Rule 506. So I wanted to give you an opportunity to tell us a little bit of your thoughts on that rule.
Sure. So what we're starting to see is slowly but surely, companies are actually starting to take advantage of Rule 506C. And so many of you may know that the SEC has lifted the ban on general solicitation and general advertising in Regulation D offerings, provided certain criteria are met. So specifically, you're only permitted to sell to accredited investors, and you actually have to take heightened steps to verify that those investors are in fact accredited. Initially, there was a lot of reluctance on the part of companies as well as platforms to move from 506B space into 506C space. But more and more we're seeing companies and platforms get comfortable with the concept and make the move.
What's the difference between B and C?
Sure. So Rule 506B allows you to sell an unlimited amount of your securities and an unlimited amount of money to an unlimited amount of accredited investors. So those are, high net worth individuals or individuals with high incomes or certain institutions. Or 35 unaccredited investors, provided that you don't generally solicit your securities. 506C allows for general solicitation and general advertising of your securities, but you're only allowed to sell to those accredited investors, and you have to take heightened steps to make sure that your investors are in fact accredited. So the old-fashioned check the box is no longer acceptable if you're in 506C space.
Is it true, and don't take me too literally, but does the C in the 506C stand for C as in crowdfunding?
Well, in some senses, I do think that's true. And I do think of 506C as permitting crowdfunding, but I would say not of the crowd, right? So you can generally solicit your securities. And if you think of crowdfunding as basically raising dollars online from a large number of people, then essentially you are crowdfunding, except for you're not allowed to take your dollars in from everybody. So the crowd doesn't get to participate, just a select group of the crowd does.
Now I'm going to throw you a curveball.
Okay.
In this day and age, when you're raising money, and obviously, optimally, when you have the general solicitation allowed, what is the envelope? Where's the gray area begin that companies should be weary of, especially asking an attorney?
So I would say not knowing what they're doing. And if you are generally soliciting your securities and you're planning on using Rule 506C, that's fine. It's a permitted exemption. If you're planning on using 506B, there's different steps that you're going to take. So for example, one of the places that we see that our clients might get into trouble is going to a demo day or some sort of pitch competition where they're actually pitching to a group of investors, but it was a group of investors that were generally solicited to be in the room. And so they finish up their pitch competition with we're in the process of raising $20 million and we've already have X number of commitments and come see me afterwards. Well, you may have just effectively generally solicited your securities. And so the gray area that we find is that clients not knowing when they're actually generally soliciting. Part of that is because the SEC hasn't actually defined what general solicitation is.
So you're saying it's the difference between sending a numbered prospectus or PPM, which specifically you're sending it out to a particular investor. You have his name, address, and he's qualified based on his answer to the questionnaire, as opposed to going into a room, making a pitch. There's 35 people sitting in the room, and technically speaking, because he told how much money he's going to raise, he may have effectively used up his allowance.
He may have generally solicited in that case, right? It's certainly possible. It depends on how those people got into that room.
So let me ask you another question. A great deal of our audience happens to be accredited investors. So what would you recommend to an accredited investor in today's market for investing in some of these companies that are soliciting directly to them?
Making sure that the company is actually sophisticated enough to know how that they're complying with the rules. And so if you're talking to a potential company and they're not aware of the distinction between 506C and 506B, then you should be concerned, because if they are in fact generally soliciting, then they need to take certain steps to make sure that their investors are in fact accredited. And if they're not, then they can't actually rely on that exemption.
So what happens to the information that an investor, for instance, gives to a company? Is that available for public use? I mean, I think that's an important question that I would have if I was an accredited investor.
So it's a great question, and that's actually one of the reasons why Rule 506C, I think, has been so slow to become popular, because investors are really hesitant to deliver their personal information to companies that are, a lot of startup companies, for example, just don't have the infrastructure to comply with data privacy laws.
So that's a good thing for an investor. For instance, if he goes to a conference and a pitch, like you're saying, he needs or she needs to ask a few appropriate questions. For instance, does the company have a website? Can you put your information into a lockbox, for instance, on their website? Will they be solicited in general on a continuing basis? Let's say if they took the opportunity to register for an online platform, for instance, a crowdfunding platform, do they have the same requirements, the platform, as the company would itself in observing the privacy laws?
So the platforms, what they're going to collect is going to be different depending on the type of platform it is, whether they're a 506B or a 506C platform. And the privacy laws are actually a state-by-state law compliance. And so some platforms are going to find themselves subject to 50 state privacy laws.
So you just brought up a fantastic point. Okay, so Reg D 506C and B are federal. Mm-hmm. How does the state law on soliciting, does the federal rules and regs supersede state?
So essentially, the federal rules do supersede the state rules. There's preemption requirements. And so the state rules are effectively preempted by the federal rules, with the exception that the federal rules do permit the states to collect information. Basically, it's a notice filing that you make with the state, letting them know that you've done this solicitation. And of course, most states collect a fee.
You know your stuff. No, I want to. Is there any other comment you'd like to make to an audience of accredited investors, non-accredited investors, and many C-suite executives and institutions? Is there anything you'd like to say?
I guess I would just say be cautious. There are a lot of platforms out there that permit investors to invest in companies that seem exciting and innovative, but you have to remember that it's not shopping on Amazon, and that you need to do your homework and do your diligence just as if you were doing a traditional private placement, and also be sensitive to the requirements of the law. And not all of the platforms out there are complying with the laws right now.
Ladies and gentlemen, Kristen Young, Zag-S&W, attorneys at law. This is a Wall Street View. I'm Shelley Kraft. We're on SNN Live. We're at the Aegis Capital Healthcare and Technical Conference 2014 here in Las Vegas. Kristen, thank you so
Shelley.
much for coming on to SNN.
Thank you. It was a pleasure.
You're quite welcome.
Thank you.